through the 60s, 70s. It began to be important in the 80s when the Charter came in and people became more conscious of rights. People were more apt to consider themselves victims of discrimination. There was an increasing awareness that Aboriginal peoples have been very badly treated. So that, you know, by the end of the 1980s, the contrast between how I was received in the court when acting for an Aboriginal group was 180 degrees from what I experienced in the 1960s on that Regina and George case. So the world moves, and I think that you're aware that the line is changing, but you're not necessarily aware of the intensity with which later generations come to see things which you took for granted. For example, the whole thing with Sir John A. Macdonald. I understand, obviously, the concern about the residential schools, but it seems to me a lack of perspective to go after Sir John A. Macdonald and Edgerton Ryerson and so on by taking one aspect of their career and blowing it into their whole career and canceling them on that account.
Yeah, I agree. Certain things could just unfortunately ruin a career unnecessarily. One big issue these days, COVID-19. I'm wondering how it's affected your life how's your working life, your professional life, your personal life. Has it been different? And then, the follow-up to that, and this is a big honor of me to ask Your Honor, the judge, something like this, a constitutional question. These days, there's the vaccine debate, and the question becomes how much can personal rights be infringed upon? So just as an extreme example, I was talking to a colleague in Malaysia back in July, and he said the government shut everything down until December 31st, the end of the year. That seems like an extreme measure. There's different measures like employers being allowed to force their employees to get a vaccine, getting vaccines being a requirement to do certain things, enter certain places. There's a movement, however you may feel about them is one way or the other, but from a personal rights point of view, where does that line drawn? There's a whole movement saying don't force me to do things, and it's an infringement on my rights. So I could foresee a case like this maybe coming before the Supreme Court. So maybe you can talk us through the deliberation process and maybe which way a court would go on something like this.
Well, on the COVID-19, of course, the huge difference has been everything having to be done remotely.
Yes.
And work has altered immensely, and will continue to affect people. I read that a bunch of the Toronto law firms, including my firm, Lenzner Slatt, is going to require vaccination. I don't have any trouble with that. I don't think it's a civil rights issue. I think it's equivalent to the aviation instruction. You don't need to undergo surveillance, but if you choose not to board the aircraft, if you're not prepared to get vaccinated, don't come into the office. I think it's not much different than the seat belts. People say, well, I should have the freedom not to wear a seat belt. That's my business. Well, it's not your business, because if you get into a crash and you get badly injured, the state picks up the cost of caring for you because you're too stupid to take precautions on your own behalf. There have been proposals, wild proposals saying, well, all right, you don't need to get vaccinated, but don't expect to get medical treatment if you get COVID-19 and you haven't been vaccinated. or don't expect the government to pay for it. It'll come out of your own pocket. I think it's a very selfish business, this refusal of vaccines, because it increases the vulnerability of the society to increased exposure, increased mutations, and so on, even though people who've been vaccinated can be carriers of it and so on. So it's not a simple thing, but seems to me vaccines, vaccination certificates, wearing masks, you have certain freedoms, but they're limited by what is demonstrably necessary, appropriate in a democratic society. I'd be very surprised if the courts held that these things are not demonstrably necessary. But in any event, private organizations, restaurants, nightclubs, and so on are not bound by the charter. They can run their business as they see fit. Personally, I would feel better going to a restaurant knowing the people have been vaccinated than not knowing whether the people I'm sitting next to have no vaccinations and have been exposed to COVID-19 in their workplace.
Fair enough. I want to zoom in here on your Supreme Court years. We don't have that much time left, so if we can go there and start with, I read this, 500-page book or so, and it was very interesting because it gives the insight into a bit of the relationships of the justices. So maybe you were there for over 10 years, 13 years. Talk about the relationships, the importance of relationships, and maybe how you can be productive with relationships or despite them, and how it works a little bit, maybe your experience.
Well, I think it varies from judge to judge. I think the personal relations among the judges are very important. I think you can't have a situation on a court of 9 judges where some judge or judges are not talking to others, as you have on the provincial appeal courts or trial courts. And everybody simply has to get along as part of the job description. That said, some judges get along better with one another than others. And, you refer to Claire Laurier-Dubé. She had a very strong personality, and some judges reacted against it. Some judges acted very strongly in favor of it. I think a number of measures are taken to preserve relationships, to prevent any judge from feeling on the outside, from feeling that a group of 5 judges has already heard what they want and decided the case before it's actually been argued in court. That's one of the reasons why almost everything is done in writing within the court. So if I have something to say about a particular case, or where Claire Laurier-Dubé has circulated a draft judgment, everybody gets to know my view at the same time. I don't go up and down the corridors, seeking support for or against whatever my position is. When I got to the court, there was a understanding that you didn't discuss cases before oral argument. And again, that was to prevent cabals forming within the group of judges to skew the outcome or prejudge the outcome or force the outcome. And that, was a very carefully thought out measure to maintain good relations among the judges. So it's critical that the judges get along with each other. By and large, I think they like each other and respect each other. But without that, respect, the court couldn't function.
absolutely. And your years there do. I mean, what major cases stand out as significant and meaningful for you?
Well, some of the cases are, stand out because of the subject matter, like the Quebec secession reference, some of the national security certificate cases, certainly Chaouli on healthcare, Burns and Raffi on the death penalty, the same-sex marriage cases. By definition, most of the stuff that gets to the Supreme Court is important. It has to be of public importance or it's not accepted. Leave isn't granted. A lot of the criminal cases were of great interest. Police powers, the whole business of gun control, whether somebody picked up for a traffic offense, it turns out they have a gun and they get charged for possession of a gun, or drugs are spied. So somebody driving, through a red light suddenly is on a major drug trafficking charge. You saw last year that Indian chief in Alberta, whose truck apparently didn't have a renewal certificate, and he kind of got physically beaten up by the Mounties on some minor issue. So you certainly have a sense in all of these issues that these are of significance not only to the parties but to the broader society, and you derive a great sense of privilege in being part of delivering an opinion, delivering the judgments on those issues. I also thought the personal side of the Supreme Court very rewarding. I liked the people. There were lots of interesting functions. We had exchanges with other courts in other countries. And that itself gave kind of global perspective. That was very interesting.
Did any one international court or judge stand out as, they swayed the court in one way or another?
No, I don't think they swayed the court at all, but I think that the exchanges were, well, I'll take two contrasts. One was a visit we had to the top court in the constitutional court in Russia, which is has a somewhat questionable legal system, and it was pretty well acknowledged, by the judges that there was interference by the government. In fact, at one of our sessions, the head of the Constitutional Court proudly stated that before our meeting, he'd had a discussion that morning with President Putin. Well, that struck us differently than the way he intended it.
Right.
On the other end, we had a very good series of meetings with the German Constitutional Court. They have a very developed human rights system, a very interesting and apposite jurisprudence. We had very interesting meetings with the Israeli Supreme Court of Israel, where we got exposed to this debate between whether you emphasize Israel as a democratic and Jewish state or as a Jewish and democratic state, and which prevails. So all of these, I don't think, provided particular instruction for how we went about our work in Canada, but it certainly enlarged our vision as to how judges operate with different issues in different jurisdictions.
That's really fascinating. Looking at it from the public's point of view, as even lawyers who read cases, is there any insight you can give us into reading a case? And what I mean by that is, first of all, generally speaking, but specifically, there's an interesting law in Jewish law that says if there's a unanimous judgment, you shouldn't believe it because it means the one who didn't get any votes didn't have good representation. So is there anything to read into the amount of judges on either side, you know, a unanimous judgment one way or the other? Anything we can glean from someone who sat on the highest court, just into reading into judgments generally?
Well, I mean, I think there are different messages being sent by the court. For example, in the Quebec secession case, the court was very careful to issue the reasons by the court, not in the name of an individual judge. The idea being that the court gives it more authority and less to argue about, because if it's written by Judge X, then critics will say, oh, well, everybody knows Judge X is a left-wing nut or a right-wing nut or a, you know, enthralled to the business world or whatever. So there's that. Then it is important to get at least 5 judges on a case because, or on a judgment, because at that point, you know, like it or not, that's the law. After you get 5, then you can have concurring judgments and dissents, which I think are useful because they bring out into the open debate which is taking place on the court. But I think the court fails if it doesn't produce at least a majority of judges on the one set of reasons. Concurring judgments are rarely, I think, of great importance. They tend to be a bit of a gloss on what the main judgment has said, but it undermines the credibility of the main judgment to some extent. A dissent, if it's a serious dissent based on a serious point, which it obviously should be, I think is valuable for debate and involving the legal profession in some of these issues. For example, the whole question of whether you can recover compensation for purely economic loss. There were a series of cases beginning in the mid-90s, which went back and forth, and there were a whole series of judgments, majority, concurring, dissenting, and slowly a position evolved within the Supreme Court, and eventually the law was more or less settled. Well, I think it's very valuable that lawyers can see that progression and better understand why the law is the way it is than if it was all done in a black box and the court simply said, well, here's the law, apply it.
I read once that your first career choice before law was psychiatry. So wondering how much of psychiatry do you see in the practice of law, in arbitration and mediation in particular?
Well, I think there's a lot of psychiatry in the sense of having to understand people and explain what they're up to. Certainly in criminal cases, a lawyer who presents a successful speech in favor of the accused has got to understand the accused and the position the accused was in, if there are any extenuating circumstances. In addition to the legal points, to bring out some kind of emotional basis on which to acquit. I think understanding why businessmen operate the way they do, understanding how judges, act the way they do, other counsel. I think lawyers are constantly resorting to a kind of amateur psychology of what's going on in the head of your opponent, your judge, your client, the other side, whatever.
Right.
I think the law has a lot to do with psychiatry. It's got a lot to do with theater. It's got a lot to do with history. That's, I think, what is one of the main attractions.
Yes. So, before we let you go, are there any wise words you can just share with the younger generation of lawyers among us or those looking to get into law?
Yeah, I think it's important for young lawyers to give some serious thought as to why they went to law school, what really they want to be able to say to themselves when their career is over, and whether they accomplish what they set out to accomplish. I think there's a real danger as a young lawyer of getting into a firm, getting quite pleased with yourself, buying a house with a huge mortgage, cars, marriage, children, and you lock yourself into a career path that you may not want to have. I know a lot of lawyers who are doing work which they would dearly get out of if they could. They're not enjoying it, but they do it because it brings in income. So I tell law clerks, students, anybody who's interested that they should really be vigilant to determine whether their career is progressing in the direction they want. Not to sit back and say, oh, well, life will dictate its own agenda and I have to go along with it. I think on the contrary, you can make your breaks, as we discussed earlier. You can go out and make a practice where none would otherwise have existed. And if a law firm that you're with is a constraint on that, they don't want you to do it. They want you to stick at the bread and butter work. Then you're in the wrong law firm. You should leave. You shouldn't be afraid from jumping from job to job. If you're good, the firm will be very anxious to retain you. Young lawyers, I think, underestimate their bargaining power. They are not only the lifeblood of the firm going forward, but the more able the junior lawyers, the more effective the senior lawyers. So as a senior lawyer, if I found a young lawyer who was really helpful and bright and hardworking and so on, well, I considered it a huge advantage, and would mentor to the extent mentorship was accepted, and seek help to the extent help was offered. So I think you're captain of your own fate. I think you can get knocked off course by events, but the important thing is to know where you're trying to go and why you're trying to get there, and to keep track of time, because in no time at all, it'll be 55 years since you were called to the bar.
That's really incredible. I mean, again, that's such a long career, and they say you retired from the Supreme Court back in 2011, but you've barely retired. You're still working, and you're still speaking to us, to myself. So, what's your view on retirement, and what's the key to longevity?
Well, I think judges, retired judges, are in a different position from retired lawyers. I think, and I'm now speaking of the litigation people, there's a huge amount of stress involved in litigation. You've got clients barking at you all the time. You've got difficult issues. You've got difficult opponents, difficult judges, difficult courts. So I think after 30, 35 years, the litigation lawyers are just sick of it. And they're quite happy to throw in the sponge and go off golfing or travel or what have you. I think if you go to the bench, you have a transition where you get very interesting work. You're not under the same stress. You have much more control over your life, over your work-life balance. So I think when you retire from the bench, you're probably still interested in the subject matter. And it's easier to transition into a post-retirement practice, or arbitration or whatever. because you don't have the same burnout factor as a hardworking litigation lawyer does, up to the point where they say enough is enough.
Right. Well, you should continue for many, many years to continue working and teaching and growing and sharing your wisdom with the rest of us. I've certainly enjoyed it, and I'm sure everybody else will as well. So again, thank you so much. And I'll leave you the last word before we let you go.
Well, only to say that I don't know how wise the words are. I can put on the table my personal experience. Others can make up their own minds. I should just leave talking about career paths. I was at a Jessup moot a few years ago, and the dinner speaker was the managing partner of White and Case, of course, one of the largest law firms in the world, based in New York. He's a guy from Ottawa. Yeah. And he delivered the message to the students that when he'd been called to the bar, joined White and Case, had a chance to go to Moscow. Everybody told him it was a career killer, sort of outpost of the firm. Well, he was there, and then he was in the Far East, and he kicked around the firm, and then he was in different parts of White and Case. And everybody kept telling him that this was not the correct career path, that he was getting a reputation as a dilettante and couldn't make up his mind what he wanted to do and where he wanted to live, so on and so forth, right up to the day he was elected managing partner of the firm. Uh-huh. So his message was, follow your dream, do what you want to do. If you want to do it, then you're likely to be good at it, and you're likely to do it with enthusiasm. So I thought that was a very good message from somebody who's prominent, really, in the global legal community, and words of good advice. So I would echo them.
I love it. I love that advice, and I take it to heart, and I try to live that way as well. So I second that, and we should continue living that way, for many, many years to come, and enjoy every day.
Okay. Well, thank you, Avi. Good luck with your series.
Thank you.